Good evening, everybody. Thank you so much for joining us. I'm delighted that we are here at BES, are hosting this event, Israel's Proposals for Area C, the Misconceptions and Misapplication of International Law, with Natasha Hausdorff, Director of UK Lawyers for Israel. I'd first like to thank Jonathan Taylor for his help in organizing this evening's event. And our speaker has agreed to take questions at the end of her presentation. So please use the chat facility in Zoom. Only on Zoom we'll be able to take questions, but if you also want to put your hand up at the end, you can use that facility as well. I'm going to hand over to our chair for this evening, Jonathan Arkush. Jonathan is a barrister. He's also a part-time judge in the High Court, mediator, and immediate past president of the Board of Deputies of British Jews. He's also a deputy representing the Bournemouth and Elsie Synagogue and has been so for over the last 30 years. So I'm delighted to ask Jonathan to start off the evening, introduce our speaker. Jonathan, it's over to you.
Thank you very much indeed, Rabbi. Good evening, and it's really good to be with everyone. We really are privileged tonight to have a conversation with Natasha Hausdorff. She's a barrister at Six Pump Court. She's one of the directors of a phenomenal, dedicated group of lawyers called UK Lawyers for Israel, whose mission is to present Israel's case in legal terms. And as we may learn further tonight, that case is so often distorted in legal terms, even by lawyers. Natasha has been a clerk to the Chief Justice of Israel, Chief Justice Miriam Naor. She is experienced in national security law, having studied it at Columbia and other universities at Oxford and here. Natasha, it's a real privilege to have you with us tonight. Thank you very much indeed.
Well, it's my pleasure to be with you.
What I'm going to propose to do is to have a conversation with Natasha to try to draw out the issues, and then we'll leave some time for questions at the end. So I'm going to start this way. The subject for tonight is Israel's proposals for Area C. Natasha, that's very bland. I know you weren't responsible for it. It's a very bland title. Should we not be calling a spade and ask this question? Is it right to say that Israel is proposing to annex a chunk of Palestinian land which doesn't belong to Israel? Is that a correct or an incorrect way of putting the proposition?
In a word, the answer is no. And I think the title is born out of a real desire to provide an alternative to this term of annexation, which has taken hold, which is a misrepresentation of what these proposals involve. At their core, what the Israeli government is intending to discuss this month is the application of Israeli civilian law in parts of Area C. Now, I appreciate that's a little bit more complicated and perhaps not as attention-grabbing and headline-grabbing as the term annexation. But my concern behind the adoption of this term really is that it leads to a second misconception, and that is that what Israel is proposing would necessarily violate international law. There is a general accepted definition of annexation. It can be easily found in the Oxford Public International Law Encyclopedia, and it's clear that the term involves the appropriation of territory belonging to another state. That's clearly not what we're dealing with here. The proposals, as they have been addressed to parts of Area C, of course refer to the part of the West Bank which was maintained under Israeli jurisdiction through the Oslo Accords. So those accords split the West Bank up into areas A, where the Palestinian Authority has entire civil and military control, area B, where there is a division between the Palestinian Authority having civil control and Israel maintaining a military presence, and area C, where the vast majority of Israeli citizens living in the West Bank reside, and where Israel has maintained full jurisdiction. If you're happy for me to go straight into it, the crux of this and the reason that these proposals have been mooted in Israel over the last couple of decades, it arises from a temporary situation, a temporary administrative framework that Israel established in 1967 when it retook this territory in the 1967 war and it recovered it from Jordan. It anticipated, in the same way that a peace agreement was reached with Egypt and significant territory, the Sinai Desert, was returned to Egypt as part of that peace process. Israel anticipated that peace would be achieved, hoped that peace would be achieved with Jordan in short order, and it anticipated that that peace accord would involve some change to territorial borders, a political decision as opposed to, say, a legal one, but one that would have legal consequences. So the temporary administrative framework that Israel established in 1967 involved the maintenance of pre-existing Ottoman law, pre-existing British Mandate law, pre-existing Jordanian law, and it included Israel's application of certain aspects of the law in international humanitarian law, often referred to as the law of occupation. And it's this patchwork which has been maintained, that temporary situation, for a period of 53 years, at which point there have been many in Israel that say it's unacceptable, that this particular territory be kept in this sort of limbo, with a temporary framework that is impenetrable to ordinary citizens attempting to obtain basic planning permissions, but also doesn't provide for some of the key needs of 21st century life. Just by way of example, there's no environmental regulation built into this framework. The laws as they apply elsewhere in Israel do not apply to Area C in the West Bank. So Knesset legislation does not apply as a matter of course. Now,
Natasha, can I draw out a couple of themes here, because there's so much in this subject. Understanding the point that Israel is wanting to apply some more settled framework than a temporary sticking plaster, if you like, that was put there in 1967, perhaps anticipating we might have got a bit further than we have in the last 50 years. Does the application of Israeli law to Area C, which you've reminded us is the area comprising Israeli population centers in the West Bank, does it imply that what Israel wants to do is to incorporate those areas permanently into the state of Israel? Question one. And question two, I know you touched on it, but we'll need to come back to it, and then we'll look at the reasons why. Can Israel do it? Should Israel be doing it? Is it taking land which really belongs to someone else? You said another state, but is it enough for this purpose that it may not be a state, but it may be a people, Palestinians? Sorry, that's rather three separate questions, but I hope you got them. Otherwise, I'll come back to them.
Well, the answer to all of them, Jonathan, lies in the status of the territory that we're discussing, now that we know that it's parts of Area C. And the status of that territory is something that we can see is established in international law in 1948 at the establishment of the State of Israel. There is a fundamental principle of customary international law that applies at the birth of states to regulate their borders, to determine and to fix at the moment of independence, secure borders, firm, indisputable borders. The International Court of Justice, when it explained the development of this principle in a case called Burkina Faso Mali, talked about the importance of avoiding fratricidal struggles and disputes arising at the formation of new states. So this principle was established to promote certainty and to provide stability and to avoid conflict. And the principle that applies to the establishment of new states is that the new entity assumes automatically the borders of the pre-existing geographical unit. It developed in the 19th century in South America. It was consistently applied in Asia and in Africa, and it also really famously governed the dissolution of the former Yugoslav Republic and the dissolution of the Soviet Union. It's considered to be a universal principle, and it applies as the default rule in all of these cases. So anywhere there is no agreement to the contrary, this is the principle that takes hold. Now, it might help if I attempt to share my screen and show you the lines that this principle would have applied to. What you see here is the British Mandate of Palestine after the severance of Transjordan, which later became the Hashemite Kingdom of Jordan. And the border that we're interested in for the purposes of the debate on the proposals around Area C is the one that runs all the way along the Jordan River and then south to the Red Sea. That is the eastern boundary of the British Mandate. And according to this universally applied principle, which is called uti possidetis juris, I appreciate it's Latin, it's unfamiliar, but I would encourage everyone listening, if they're interested, to look it up, Google it, see how it's developed and how it has been consistently applied. Because that principle establishes that in 1948, when the State of Israel was declared, even though that Declaration of Independence didn't say a word about borders or territory, it referred to Eretz Israel, the land of Israel, that this principle automatically established the borders of that state at the moment of independence. Now, what that means is that during the War of Independence, Jordan occupied the West Bank and East Jerusalem from the fledgling State of Israel. That is the only application of this fundamental principle of international law that I can see to the events from 1948 until 1967, when Israel retook that territory in another war from Jordan. A lot of people make the argument about the acquisition of territory in a defensive war. The reason they make that argument is because there is considered to be in international law a prohibition on the acquisition of territory through the use of force. The reason this is said to exist is because, very simply, there is a prohibition on the use of force, unless it's for the purpose, which is recognized in Article 51 of the Charter of the United Nations, for the purpose of the inherent right of self-defense. And therefore you have people making this argument that, if 1967 was a defensive war in which Israel was forced to defend itself against invading armies, then any acquisition of territory in that war ought not to be illegal. But we don't even need to go there. What is being fundamentally missed here is the formation of Israel's borders in 1948 and what this principle says. Not applying it to Israel and dreaming up some alternative would be a breach of international law in and of itself. It would be in violation of the principle of the equal application of law, where there is no good reason for this principle not to govern the formation of Israel's borders, as it does with every state that emerges in similar circumstances from a pre-existing administrative entity, which the British Mandate was, then it is a misapplication, I would say even an abuse of international law to avoid its application here. Now,
Natasha, if I can help move it along by asking this. The point you've made, fundamental point you've made, is that the pre-existing entity at the time of the establishment of the State of Israel was the Mandate. And the Mandate had borders, and after they took out Transjordan, the eastern border was the River Jordan. Are there a number of ways in which international law can be formed, and one of them is by agreement or international declaration. Now, I've heard from time to time mention of the San Remo declaration. Is that relevant here? And if so, why?
I would say that it's relevant in terms of the historical and perhaps even the legal context in which Israel comes into existence. Many do argue that the San Remo conference, in which a representative portion of the international community came together and recognized the right of the Jewish people to self-determination, and recognized the importance of the establishment of a Jewish state in the land of Israel. Many people therefore argue that it does create an international consensus and therefore a legal obligation on the international community to follow through on that. Of course, I don't argue with that. I think, though, that the situation can be made far simpler. We're not asking for any special treatment for Israel. We're very simply asking that the same international law be applied to the establishment of the State of Israel as it is to every other country that emerges, and that the same fundamental principle of international law be applied. A lot of the pushback against arguments around San Remo arises from an argument that it was a recognition of a right to Jewish self-determination, but it didn't recognize a correlative right to Palestinian self-determination. Of course, the eager members of the audience may cotton on to the fact that during the San Remo conference, even during the formation of the State of Israel, there had not as yet been the same Palestinian national identity formed as came with Yasser Arafat in the 1960s, and that the type of Palestinian self-determination which we talk about and strive for today is a very different phenomenon. I
was going to ask you about that, because when you look at the screen which you shared, there is of course no reference to any Palestinian area, and the concept of Palestinian statehood doesn't seem to have figured at all until the 60s. But things moved on after 1948. Don't we have to make some adjustments or accommodation towards Palestinian aspirations? And how does that affect your argument about the borders in 1948?
Oh, absolutely. And that is a political question. It is certainly not my suggestion that what was the starting point in 1948 ought to be any indication or guide as to how we move forward through bilateral negotiations. The starting point in 1948 is fundamentally important to explain why these allegations of violations of international law are utterly baseless, because it tells us that this is Israeli sovereign territory, and Israel is perfectly at liberty to apply its own civilian law in those areas as denoted in the map. But of course, successive Israeli governments have made it perfectly clear, and latterly that has been proffered in terms of the two-state solution, that since Palestinian national identity has been latterly formed, that some accommodation for that is necessary. And of course, that is what Oslo created with the formation of the Palestinian Authority, which governs absolutely in Area A. Of course, subsequently, we've also had the emergence of Hamas in Gaza, which governs absolutely in the Gaza Strip. So there is a form of Palestinian self-determination at present. Of course, it's important to stress, as a matter of international law, the principle of self-determination does not give everyone a right to a state of their own. We just need to look at the example of the Kurds to see that that is not the case. There is a famous case from the Canadian Supreme Court that really has become seen to be part of customary international law, which sets out what it is that self-determination provides for. And it is a form of self-governance and a form of political self-governance, which the Palestinians certainly do have in areas in the West Bank and the Gaza Strip. That is the status quo. Negotiations have sought to improve that for ordinary Palestinians. I personally think that it is devastatingly sad that the Palestinian leadership seems to let down ordinary Palestinians at every juncture, and that those negotiations have not come to fruition.
Let's come to politics. Before we come to politics, can I just go back to this word annexation? Have I understood you correctly? You can't annex what's already yours, because the principle that you mentioned, it must mean, I think, this is the burden of your case, that the whole of Israel, right up to the Jordan River, under the international law principle that you mentioned, says that this is Israel's sovereign territory. So annexation is wrong, because annexation means taking something that belongs to someone else.
It's absolutely right. Annexation means taking for yourself territory belonging to another state. It's what Russia did with Crimea in 2014. It's what in 1940 the USSR did when it annexed the Baltic states. It's what happened when Germany annexed Austria in 1938. And you can also say it's what Jordan tried to do with the West Bank between 1948 and 1967. And that is a violation of international law. But as we've discussed, what is being considered here by Israel in Area C does not involve another state's territory. And very, very importantly and bluntly, it is not annexation. And use of the term annexation has caused, I think, so much uncertainty and skewing of this debate. Now, the secondary important point here is that it is not illegal. Now, that is also something that is contrary to what seems to have become the received wisdom. And as you say, since its independence in 1948, the only state that can be described as sovereign in that territory is Israel. And it's this universal principle that tells us that, very simply, Jonathan, not applying that principle to Israel is a double standard. And that is the true violation of international law, that out of all of the countries in the world, Israel would be treated differently in this respect.
So I'm going to come on to double standards in a moment. So the logic of your argument must be that Israel would be entitled to go beyond the mere application of Israeli domestic law to Area C, or parts of Area C, the parts in which Jewish people have settled and established Jewish villages, a term I prefer to settlements, which is, I think, also apt to be loaded. And they could go beyond it and say, we're actually going to incorporate this area into Israeli borders because we're not taking it from anybody else. Well, would you go that far?
I don't think that's quite accurate, because there's no incorporation needed. And it's international law that tells us that from 1948, this has been Israeli sovereign territory. So the very suggestion that there would be a change to the status of the territory is problematic here.
So it's already Israel.
Fundamentally, yes.
In that case, I'm trying to understand, and perhaps you can help us. Why is it that there has been this enormous campaign raised, certainly in this country, which we're most familiar with, and why do you think there has been this recent letter sponsored by Sir Mick Davis and signed, it appears, by a number of senior English judges, including retired judges of the Supreme Court? What do you put that down to? Is this, are they saying something? Are they saying something that we're not paying attention to, or have they, in your view, just got this wrong?
Well, it's a very short letter. It's actually impressive that it manages to get so much wrong in so few words. It's unfortunately, I think, a product of the groupthink around this and how politics plays into questions of international law. It's a clear example of the rhetoric of international law taking over from the reality of it. Now, that letter you refer to focuses on the question of occupation. So it fundamentally rejects the application of the principle of uti possidetis iuris, doesn't provide any reasoning or analysis to do so. And it therefore proceeds on an entirely unreasoned premise to be making the sorts of claims that it makes.
Because on your argument, occupation must be as erroneous as annexation, because you can't occupy what's already yours.
And the reason that the term occupation, which is really in this case used as a political term as opposed to a legal one, but the reason that I think it's gained particular traction is that because as part of Israel's temporary administration, it decided to apply aspects of the law of occupation to its governance of the West Bank as a whole. And as a result, it's what the Supreme Court has looked to when it has tested questions and petitions that have been brought to the court, often by Palestinians with respect to individual building initiatives in the West Bank. And the court has looked at each of those cases on its merits, in certain cases deciding, for example, in the matter of Elon Moreh, that the reasons for military expropriation of private land were not convincing to the court. And it ordered that that settlement be removed. In other cases, for example, Bargil, where the question was a political one and it was brought to really test the status of the territory in general, the court said, we're not prepared to deal with that because it's a political question, it's not a legal one. I think that's particularly telling because it underlines the principle that the court, this is the Supreme Court in Israel, sitting as the High Court of Justice, has grappled with these difficult legal questions using the political legal framework that Israel applied in 1967. It's unfortunate that it has also led to the misrepresentation of the situation that we are dealing with. And to a certain extent, it is a unique set of circumstances. It arises from the protracted nature of negotiations and sometimes the absence of negotiations in finding a final settlement to this protracted conflict, and Israel's efforts to seek that solution, first of all, with Jordan, and then subsequently after the formation of the Palestinian Authority through the Oslo Accords with the Palestinian representative leadership. But that is, I think, the crux of the issue. Now, there are so many parts of this debate that are fundamentally misrepresented. One, it's a minor issue, but I think it's representative. One point that I've been hearing thrown about pretty consistently in discussion here in the UK is that this date of the 1st of July was considered to be some sort of deadline. It's absolute nonsense. The 1st of July is set down as the starting date in the coalition agreement for discussions within the Knesset to take place to determine exactly how these proposals should be carried out. But it has been misrepresented in a similar fashion to say, oh, now that we've hit the 1st of July and nothing has happened, there must have been some delay to the process, and the anti-annexation, as they tell themselves, campaigners are seeking a sort of victory out of that.
So it's early days at the moment, and the distinction which you've highlighted, a very important distinction, must be separate legal principles from political considerations. One of the things which this letter does is that it charges Israel with having rejected the two-state solution. Would extending Israeli law to Area C prejudice a two-state solution?
Not in any way. Any proposals around a two-state solution have envisaged sovereign Israeli territory being transferred via land swaps. Most recently, the Trump plan sees significant parts of the Negev being transferred in that fashion. So it doesn't affect the prospect of negotiations at all. Israel has consistently negotiated over land to which its law has been applied in full in the past, and it is indicated it has every intention of continuing to do that. So this is another slander, if you will. Now,
you start with the law, and then you say, well, for political considerations, should we, despite our legal right to ownership, compromise?
Oh, and Israel has been very clear about its intention to do that. And in fact, so much so that you won't really see the government referring to the original starting point in the legal situation. The focus of successive Israeli governments has always been on the political solution. And to that end, it engaged with Oslo. And to that end, more and more generous offers have been put on the table since then. If you want to talk about, the politics of it, there is a question as to whether that approach, which has been at the instigation of the international community, of every time negotiations break down, there being an expectation that the next offer Israel is putting on the table is even more generous than the previous. Well, logic would dictate that that sort of approach can only lead to the further breakdown of negotiations. But you're absolutely right that the legal starting point is not one that Israel is promoting as a final end point. The reason it's crucial for our discussions is because it is so frequently misrepresented. And it is because on the basis of those misrepresentations, the allegation of violation of international law is made. It for me, bears striking resemblance to the blood libel. That, of course, was that canard that circulated in medieval times and was widely accepted, that Jews killed Christian children to use their blood for making matzah, for Passover. We've had so many varied manifestations of that blood libel, but today, the libel against the state of Israel, the Jewish state, is that it violates international law. Now, whether that be on the battlefield with violations of international humanitarian law, the law of armed conflict, or whether that be in the context of public international law and the question of territory, the falsehoods are the same. And it is this tsunami of slander that has prompted the sorts of letters that you refer to. I don't know if every signatory to that letter fully understood what it was that they were signing up to. I certainly know that there are professors of international law that have signed on to these also, but they, and certainly the letter, does not address the fundamental customary principle of international law that determines borders and why it doesn't apply in this case. And I humbly, respectfully suggest that there isn't an answer to it, which is why it is brushed over. I also appreciate that in terms of the media discourse on this, terms like annexation and occupation, all be them false, are far catchier. They make for far more sexy headlines than a proper analysis of Israel's rights under international law. And it's always been an awful lot easier to lambast Israel and slander it and criticize her for things that she hasn't done, than to stand up and say, well, actually, this isn't quite right. I appreciate that.
A lot of people would say that the sort of slanders that have been levelled against the Jewish people now find their expression in slanders levelled against the state of Israel in an effort to undermine its legitimacy.
And I think the real tragedy around this that we mustn't ignore is the impact on ordinary Palestinian people. I spoke earlier about how their leadership, I felt, had let them down. And I say this as not someone from within the Palestinian community, but someone from outside looking in, which I fully appreciate. But if you look at what these proposals may very well include, so they would mirror, the discussion is, the application of Israeli civilian law when Israel applied its law, jurisdiction and administration to East Jerusalem in 1967. We're talking about the same sort of framework. And what happened is that local non-Israeli inhabitants received Israeli residency and the option of Israeli citizenship. Now, what that brought with it was access to healthcare, social security benefits, the right to vote in municipal elections, and of course, the option of Israeli citizenship and being a citizen of the only democracy in the Middle East. And it's for that reason that when similar proposals were mooted with respect to suburbs of Jerusalem, additional suburbs of Jerusalem a few years ago, there was substantial talk of local Arab residents moving into these areas preemptively in an attempt to benefit from the acquisition of these rights if they fell into areas of full Israeli administration. It's also incredibly important in the context of a report that was done by the head of the Arab desk at News 10 or Channel 13 News, a journalist called Tzvi Yechezkeli, went into parts of Area C to interview ordinary Palestinians and get their views on the proposals and how they might be impacted by it. And even though he hid their identities and changed their voices, for those that he interviewed that said that they would welcome the prospect, that they would certainly jump at the chance of Israeli citizenship, and that the prospect of being governed under the democratic regime of Israel is day and night in comparison with the corrupt authoritarian Fatah regime that they face. Well, the follow-up to that is that this journalist, Tzvi Yachezkeli, was informed by the family members of individuals that he interviewed that many had subsequently been identified and been arrested by the Palestinian Authority because what they were saying was so out of sync with the party line that must be presented. I think that's incredibly telling. And I think, in fact, the manner in which this is being reported and discussed outside of Israel is doing ordinary Palestinians a severe injustice and mirrors the approach that, unfortunately, the international community has taken with respect to the conflict as a whole, which has pushed peace further away, generated, I think, unrealistic expectations, and tied the hands, indeed, of the Palestinian leadership. Jonathan,
let me ask you, if I may, about other territorial disputes in the world and whether we can learn anything from, for example, the occupation of Tibet by China, the invasion of North Cyprus by Turkey, and the I think it was an annexation, wasn't it? A following invasion of Crimea, part of Ukraine, by Russia. Is there anything we can learn from them?
What we can learn from all of them is that the allegations that are made against Israel about it violating international law are solely made against Israel. The article of the Fourth Geneva Convention that is quoted in order to attempt to justify the position that settlements are illegal, Article 49.6, has never been used in any situation of real occupation that you describe, including also Nagorno-Karabakh, in Cambodia, Vietnam, in the occupation in Lebanon, Syria. There is consistent international state practice to say that situations of actual occupation which involve settlement projects that are often designed to change the demographic situation have never been criticized in the context of this Article 49.6, which is used to justify criticism against Israel, with one exception, and that is with respect to Northern Cyprus, where Cyprus has advanced that argument, but it is the only one, and it has not been taken seriously on it. So it's
double standards?
It's another blatant example of double standards, absolutely.
Just stepping back for a moment, the storm of protest around the world, including from our own government, which proclaims itself to be sympathetic and friendly to Israel, is it worth it for the Israeli government to proceed with a plan to extend Israeli law, to undermine its own sovereignty, if you like, given the aggravation and the hostility that it provokes in so much of the rest of the world?
Well, I think that you and I might agree that the primary focus of the State of Israel ought to be its own security interests and the interests of the people of Israel. As a democratic government, it must serve them. And therefore, this sort of decision needs to be taken with that wholly in mind. With respect to the reactions that we've seen in Europe, well, I hope that this discussion has perhaps assisted with an understanding of how incorrect the appreciation of this proposal in Europe is. And I think the problem with that is that it's not the move that people and that European states have taken an issue with. It's a far deeper misrepresentation of Israel, its rights in the region, its rights as a state, And that is not something that policy X or policy Y will necessarily grapple with. It's a much, much deeper question of public relations and public education about international law and its application to Israel.
I mean, when the American government announced that it was going to recognise Jerusalem as the capital of Israel and move its embassy there was also a storm of protest.
You're absolutely right.
Not much has happened since, has it?
So those two proposals brought with them doomsday predictions that the sky was going to fall in over the Americans taking this move. A similar set of predictions also occurred at the American recognition of Israeli sovereignty in the Golan Heights. And you're absolutely right that nothing has materialized. And so as a result, I would suggest that we take similar predictions with respect to Israel's proposals in Area C with a significant helping of salt. The other thing important to stress with respect to the region is that you have had a number of key players coming out to voice their opposition to this. Now, this is in the context of a revolution in terms of Israel's diplomatic relationship with key allies in the region. A lot of that has been born out of Israel's security cooperation. But lest we forget that Netanyahu has been able to develop close diplomatic relationships with countries including Saudi Arabia, the United Arab Emirates, and Bahrain, and three countries, in fact, who attended the unveiling of the Trump plan, the so-called deal of the century, included the UAE and Bahrain. That would have been unfathomable 10 years ago. And that needs to be borne in mind, I think, in terms of the dynamics of the region. As I say, the security cooperation that exists between these countries, which is all important. And also the key point in terms of international relations that what is said publicly doesn't always marry up with what might be said privately between countries.
Do you think that part of what might motivate Israel is that the situation we're in now is that the constant saying no by the Palestinians since 1967 has essentially amounted to a veto on any moves forward towards peace? And do you think it forms part of Israeli thinking that the time has now come to change the rules on the ground? And if the Arabs, they can't just hold things up by saying no, and it might actually be better for them to realise that the longer they say no, the less territory they get. Is that a bit of a crude way of putting it?
Well, I don't think that it necessarily impacts on what territory is on the table, as we've previously discussed. But you're absolutely right that there are significant voices in Israel saying, let's end this hostage situation. We need to govern the territory in the best manner for the people, the residents, be they Israeli citizens or non-Israeli citizens, and we cannot be held up by Palestinian intransigence. I think the key question here, though, is what incentive is there on the Palestinian leadership to seek a solution? And it's not one that's often asked when we consider that Mahmoud Abbas relies on the perpetuation of the conflict to secure his political control, to maintain his hold on political power.
He's in the 14th year of a 4-year term, isn't he?
He is, and anyone who succeeds him will face the same sort of political setup and the necessity, as with every authoritarian regime, to have an outside enemy to blame for its problems. But of course, he also relies on the international donations which flood in as a result of the perpetuation of the conflict. And crucially, which is hardly ever discussed, he relies on Israeli security cooperation to prevent a Hamas takeover of the West Bank in the same way, the same violent way that they took over the Gaza Strip. And so there is no incentive to seek the sort of entity that the international community seems to be clamoring for the Palestinian leadership. That's quite apart from their desire to do ordinary state-like activities that involve taking out the rubbish and organizing bin collections, as opposed to just attending international conferences and bringing suits in international organizations on questionable bases in international law. So that is a real question. But in terms of I think Israel's relationship with its Arab neighbors, there is also an important dynamic to bear in mind here, and that is that in the Middle East, strength is respected in countries. And when we look to Israel's proposal to apply civilian law that applies elsewhere in Israel to parts of the West Bank where there are majority Israeli civilians living, then, and considering, of course, that this has been something that has now been discussed for decades, it's not new, it's not come at the instigation of the Americans. For sure, the current political circumstances mean that the debate about this has gained traction and that it is being seriously considered. Having said all of this, however, unfortunately, the deteriorating situation with coronavirus in Israel means that this has very much gone onto the back burner. So the conversation that we are having may very well turn out to be academic. Nonetheless, it's a vitally important conversation because it addresses the key misrepresentations about the status of the territory and the misapplication of international law.
I've got one quick question, then we want to turn over to other questions. You made one very point that seems to me to be very important, that the Israeli government is a democratically elected government. And indeed, at the moment, there's a national unity of government where the alternate premier, not even Benny Gantz isn't the deputy premier, he's the alternate premier, was the leader of the opposition. So in your view, how fair or right is it for Jews in this country or other countries to point the finger at Israel and say you shouldn't be doing it?
Israel has a special relationship with the diaspora Jewish community, and I think that's right. And the government has always been alive to feedback from the international Jewish community, and it recognizes, and it has solidified this in terms of basic law in the nation state law. It solidified the responsibility that the state of Israel has to Jews all around the world. And in that sense, I have no doubt that those voices resonate very loudly in Jerusalem. The big problem that I have with the discussion and debate that has taken place internationally about this, in particular in the Jewish community, is that it does not have any basis in reality. Those are strong words, and I use them advisedly, and it is born out of a great frustration that I have. When we see Jewish organizations that are incredibly well funded and well organized launching a decisive campaign against what they call annexation, that has led to the further spread of misinformation and the further spread of these sorts of libels, and as I said earlier, this tsunami of slander against Israel. And that harms Israel significantly because it puts
not for the first time, I'm afraid.
And I would warrant not for the last either. But
no,
it makes
I'm sure you're right.
All the more important that we have voices on the other side, putting that to proof, clarifying those issues, and pushing back on the misrepresentations and the misconceptions.
We've got 3 questions on the chat, and perhaps we can start with them because I'd like to utilize the last 15 minutes or so with the questions. From Linda Davidson, why even bring annexation into the public eye when places like Ma'ale Adumim are well established?
Now, if that question goes to why use the term or why raise the policy, the terminology is unfortunate. And the fact that we've had even Israelis using this, the Israeli term sipuach, indicates a certain sloppiness to me, which needs to be addressed. It's not what we're talking about at all, but it's become the shorthand, and the sort of the group think is very much around that term. In terms of the policy, well, the importance of it is, as I explained earlier, is to address the temporary, unsatisfactory patchwork state of administration that currently exists in those areas, that holds up development, that holds up economic prosperity, and that causes so many problems. So that's really where I think the policy has come from. The fact that it's now gained traction is undoubtedly as a result of American support for this, because, you know, for better or worse, Israel does rely on a consensus in the international community over what it does. It is a small country, and if subject to sanctions, as is the discussion now focusing on that, I think is a direct result of the received wisdom of this being a violation of international law, that is undoubtedly going to be worrying for the state of Israel.
I suspect that may be the answer to the next question from Sharon. If these areas have always been part of Israel, why is it thus far Israel civilian law is not applied? Why is it only being applied now?
So as I explained in 67, the decision was taken to institute this temporary administration because the expectation was that part of this would be ceded to Jordan in exchange for peace. The land for peace phenomenon didn't begin with the Palestinians. It arguably was the root of the Egyptian peace process and would have been key to peace with the Jordanians also in the minds of the Israeli government in 1967. So from a practical perspective, applying all Knesset law to the West Bank in the same way that it did with East Jerusalem in 67 wouldn't have made sense if a few months later the situation on the ground would change through a bilateral legally binding agreement. Of course, that hasn't been the case. 53 years later, voices in Israel are saying end the limbo and the uncertainty.
Julie and Neil Myron have asked, what is the legal status of the border existing at the point of the Declaration of Independence in 1948? Do the borders existing at that point have any bearing on this argument?
So it's the principle of uti possidetis juris that tells us that the border as established on the map that we viewed together earlier is the one that Israel automatically assumes at the Declaration of Independence. Since then, there has been no agreement on borders or territory. We have had the armistice agreements between Israel, Egypt, Israel, Jordan. They very explicitly made clear that there was no question of the armistice line, which so many people today incorrectly refer to as 1967 borders. They are not borders, and they certainly don't date from 1967, but it is the 1948 armistice line, which the parties that the line concerned made it explicitly clear that it was not intended in any way to be a border or to have legal effect. Now, of course, the reason for that is that at the time, neither Egypt nor Jordan accepted the validity of the State of Israel in any borders. And so they certainly weren't going to suggest that the 48 armistice line constituted some sort of legally recognized boundary. But
I mean, putting it shortly, yes, in the whole of the 72 years of Israeli statehood, it has never had a border that's been agreed with its neighbours, save those with whom more recently it's made peace.
Indeed, and the peace agreements, which I was about to come on to, are particularly informative, I think, because they make reference to the prior borders of the British Mandate. And so, if anything, the agreements that Israel has engaged with subsequently reinforce the application of uti possidetis juris in 1948.
Any questions? This is your chance to our audience. Jonathan Taylor says, well, you're making the fundamental argument that Israel is acting in accordance with international law. Who's listening?
Well, thank you all for listening. I'm available for weddings and bar mitzvahs as well. I certainly do, and I have previously spoken in Parliament here, parliaments abroad, at universities and conferences around the world. And I have noticed that more academics, more politicians are becoming alive to the issues and the reality of international law as opposed to the rhetoric. But there is a great deal more work to do. Jonathan, I was very grateful for your kind words about UK Lawyers for Israel at the start of this session. UKLFI does phenomenal work, and it is my great honour and privilege to be a small part of it, a voluntary organisation of lawyers, although in order to grow and tackle the magnitude of the project ahead of us, undoubtedly we need to perhaps fundraise and become, an even bigger and more successful organisation. Of course, it's not just fighting back on the misrepresentations of international law that UKLFI engages with. It deals with lawfare against Israel, State of Israel against Israelis, anti-Semitism in the UK and around the world, and it has become a market leader in a sense in dealing with that.
Well, let me endorse the plug for UKLFI, and let me remember one thing that I was just so impressed with at the time. At the time of the infamous flotilla of supposed purported aid ships to Israel, one ship was waiting to leave Athens for Israel, and UKLFI stepped in extremely smartly, and with its careful professional diplomacy to the Greek government suggested that perhaps they may take a closer look at the ship. And the nautical authorities in Greece, thanks to UKLFI's intervention, decided they were going to take a look at this ship. It was absolutely riddled with the most basic safety defects. It was a completely unseaworthy vessel, and the vessel was duly impounded. A marvellous initiative by a tiny group of London lawyers working mainly without any sort of the nights and weekends. Natasha, you're part of that. I think you really have set out for us a clear view, and perhaps in answer to Johnny Taylor's question, let's reflect that Theodore Herzl spent many years, resulting in his own very early death from exhaustion, putting an argument which seemed completely out of the question and absurd to Jews and world states, which is that the Jews deserved a state of their own. That was how things were 120 years ago. Look where we are now, 72 years of the statehood of Israel, the Jewish state, a state we're all incredibly proud of. Dreams can become reality, as Theodore Herzl said it himself, didn't he? If you will it, it is no dream. So I think what I'd say to Johnny, who's listening? Not enough people are listening. Not enough people listened, but eventually we had a Balfour Declaration, and eventually we had a state of Israel. And this is a problem now, and there'll be more problems to come. I think we're probably reaching the end of our time, but if you look at the chat, you'll see that there are questions about whether any more than the Israeli government can do on a PR level. To be fair to Natasha, she's not an Israeli government representative, so I think she'd probably say there's plenty people can do on a PR level, and Israel does its best and perhaps somewhat fed up with trying. And I think also David has asked, which international authority, if one exists, would be able to preside over this issue? I'm not sure it's that simple.
I'm afraid it's not, and the international legal organisations that have thus far sought to deal with it have not done so in a particularly objective fashion, and it's one of those situations where politics has influenced the application of law. I would say that in those examples, one of them famously being the International Court of Justice's Wall opinion, where the International Court of Justice determined that the building of a security barrier to confront terrorism was unlawful, having not given any consideration to the reasons that Israel was building it, and the wave of terrorism that Israel had experienced that prompted the initiative to build it, not least the fact that the barrier also stamped out all of those suicide bombings and was incredibly effective in what it was employed for. And of course, all of the UN resolutions that have been passed with respect to Israel, calling this, that, and the other illegal. What both of those examples share is that they have no legal weight. They are not binding in international law, and so far they are just political pronouncements for the most part. What I would say with respect to the State of Israel is that it is inevitably handicapped diplomatically in being able to state its case in a full-throated fashion. In 1967, when Israel applied its law, administration and jurisdiction to East Jerusalem, Abba Eban, who was then foreign minister, made it explicitly clear to then the Secretary General of the United Nations that that did not constitute annexation. With the debate that we have witnessed over the last few months, the same clarity of expression doesn't seem to come as easily to the government, and there can be a whole plethora of reasons for that. The emphasis must therefore be on civil society and on ordinary individuals. And that's part of the reason why it's my great privilege to speak to collectives like this, to the extent that people are interested enough and passionate enough, and I hope you will be, to go away to look into this. I've written most recently now in the Jewish Chronicle, in the Jewish News, and also in the Times of Israel on these sorts of issues. There is a lot of information out there to marshal to be able to make these arguments. And as you say, if you will it is no dream. It is through these incremental steps and through this pushback that the case simply has to be made.
Natasha, thank you. Someone has asked whether there is a bit more information out there about the Latin principle that you mentioned. Will that be found in your articles in the JC or Jewish News? Is there somewhere very easy to look up and find that principle?
It is indeed. So the spelling of the principle is in those articles, also in the Allgemeine. And to the extent that we have, budding lawyers or legal enthusiasts in the audience, I cannot recommend highly enough an article entitled Palestine, Uti Possidetis Juris and the Borders of Israel by two American Israeli professors, Eugene Kontorovich and Avi Bell, in which they put this case in, I think, 60 odd pages, but they make it explicitly clear how the principle applies and where it has previously applied, the development of it, and they put the case.
It's a good article. I've read it. Thank you very much. Natasha, we are very grateful to you because you are an advocate, if I may say so, cool, sane, clear-headed, in all the best traditions of the English bar, of which I'm glad to be a part. We need more advocates like Natasha. Thank you very much for giving your time and sharing your perspective with us and putting forward such compelling arguments. I think everyone is now a great deal clearer because you've shone a light on an area that unfortunately has allowed to become rather cloudy, and that has even persuaded some people who perhaps should have known better before they rushed into print. So my thanks to you. I think the last word is going to go to Johnny Taylor, who is going to just sum up.
Just before we hand over to Johnny.
Sorry, Rabbi.
No, that's okay. That's okay. Firstly, thank you, Jonathan, for putting the questions so clearly to Natasha and allowing her to make her presentation so clearly. I had to explain when I read Natasha's article in one of the Jewish papers. I said to Johnny Taylor, I said, we have to have her come to the community. And I'm so pleased Johnny was able to make it happen. So thank you so much, Natasha. You, both in your writing and in the spoken word, you have showed such cogent and compelling arguments. And as you've shown how important it is to challenge the narrative that's out there. We thank you for doing it in such a clear, cogent, compelling, and as Johnny said, such a calm way as well. I'm delighted you were able to join us, and I'm going to ask over to Johnny because again, thanks to him that we were able to make this happen. So Johnny, it's over to you for the final word.
Thank you. So again, I would like to thank everybody for listening and participating in this event. I'm sure that we have learned many new realities that Natasha has presented to us, and certainly a thing or two about history. We thank Natasha for her most eloquent presentation, for the invaluable work that she and her colleagues do at the UK Lawyers for Israel. Thank Jonathan Arkush for his excellent mediation this evening. Thank Rabbi Chapa and the BES community, and thanks to the Zionist Federation, who often work together with the UK LFI for its Israel advocacy, unrelenting as and when it is needed in the community and beyond. Just an advance notice, if I may take this opportunity, of a Stand With Us virtual tour of Jerusalem, which will take place for the BES community exclusively on Thursday, the 3rd of September at 7 p.m. for your diary. Further details will be sent to you all. So may I say good night, and once again, an excellent evening. Thank you, Natasha, so much for coming along. Good night.
Thank you to you all. Good night.
Thank you. Thank you, Johnny.
Thank you.